Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome, my name is Nicholas Robertson and I think we're coming to the end of an era. I think this is going to be the last update that I have to do on the coronavirus furlough update scheme series that seems to have been part of all of our lives for the last month. I may be wrong, of course. There are hints that the government is considering some sort of amended version of the furlough scheme post 30th June, which is the current time for it to end. So I may yet be back doing more updates. But for now, I think this will probably be the last one. But anyway, the point, of course, is that following almost immediately after the previous set of coronavirus guidance updates, we've had two further updates. The employee guidance note and the employer guidance note have both been updated, and they've been updated in sync. So what I was going to do was focus on the changes in the employer scheme guidance note that came through on the 23rd of April. Overall, and as you would expect, the volume of changes has slowed significantly. So what we have here is some filling in the gaps and some not filling in the gaps, which is, I think, also significant. So let's start with the stuff that's been filled in, completed, whatever. Both guidance notes are now very clear about when employees need to have started with the employer in order to be eligible to be covered by the furlough scheme. On the positive side, the government has produced a table in the employer's guidance note which sets out very clearly the dates for determining whether an employee is eligible to be furloughed. If the employee was both employed before 19th March 2020 and was on an RT1 submission notifying payroll payment on or prior to 19th March, then the employee is eligible to be furloughed. If the employee joined after 19th March, they're not eligible to be furloughed. And crucially, if they joined at any point before 19th March but had not yet been on an RT1 submission by 19th March, then they are ineligible to be furloughed. This is particularly tough on employees who joined prior to 28th February 2020, but whose employer has a payroll on or after 19th March, which I assume will surely be the majority of employers. So naturally, you can understand the point, HMRC saying, look, we need to have a fixed cut-off date to avoid what might otherwise be fraudulent attempts to benefit from the scheme. But it's particularly tough on employees who'd joined after the employer's February payroll run and who have written documentation to prove the start of employment, but who have not yet been on payroll, which, let's face it, is a matter entirely outside of their control by 19th March. Indeed, given the original cut-off was simply commencing employment by 28th February 2020, there are presumably people who were originally covered but have now dropped out of the furlough scheme. And that seems particularly tough. You'd hope there aren't a lot of people, but there will be people who lose out. And indeed, given that a lot of the process of applying for this public money depends on documentation generated by the employer rather than documentation submitted to HMRC. And look, I'm thinking there, the written instruction to go on furlough, which presumably will have a date on it. But, it's a document generated by the employer and subject to HMRC audit. The employer's going to be trusted about that. So why can't the employer and employee be trusted to say, here's the contract of employment showing when I started work? But that's not the way the system works. And the government, as I say, is being super clear about all this. Whether the anger out there online that I've seen translates into any pressure, who knows? Probably not. The further we go through this, the less likely it is that there will be any retrospective changes, because then there'll be protests from employers that they would have furloughed people earlier if they'd known they could, and so on. But as I say, for now, we have this, I think, rather unjust cut-off date for employees. There's similar guidance in relation to fixed-term contracts. If the contract expired after 19th March 2020 and there'd been an RT1 payment submission for that employee prior to 19th March 2020, then the individual is capable of being furloughed and that fixed-term contract can be legitimately extended, or the individual can be re-employed. The guidance note points out that employees who joined after 28th February 2020, and whose contract ended before 19th March 2020, so they both join and leave before 19th March 2020, will not qualify for the scheme. And they say this is a general point rather than a contract, a specific point to fixed-term contracts. We were aware already that employees who were shielding and so unable to work could be furloughed. The government has now moved to make the point even clearer by expressly indicating that employees who are shielding in line with public health guidance can be furloughed. And remember, this is a permissive point. An employer can generally furlough any employee who is not shielding in line with public health guidance under general principles. So the guidance note is now simply indicating that even where employees are shielding in line with public health guidance, they can be furloughed. However, that brings up one of the less helpful developments, or I say rather the lack of development, which is the guidance in relation to employees who are on sick leave at the time the employer wishes to put them on furlough has not been altered. As we indicated in our previous advice, and I've dealt with in the podcast previously, this means that the guidance notes and the direction are not pointing in one direction. Terrible pun, sorry. Anyway, they're clearly contradictory. Some clue to the government's thinking can perhaps be gleaned from the other major unknown, which is the issue of consent and whether an employer is required to obtain an employee's consent to being furloughed, even if there are no other adverse changes to the contract. It's simply a case of you are now furloughed. On this subject, the guidance note has altered slightly in the most recent guidance. The relevant paragraph now reads, "To be eligible for the grant, employers must confirm in writing to their employees confirming that they have been furloughed." Pausing there, the fact that no one has spotted the double confirming in that sentence is a little troubling for the amount of detail they've put into this. Anyway, just reading that again. To be eligible for the grant, employers must confirm in writing to their employees confirming that they have been furloughed. If this is done in a way that is consistent with employment law, that consent is valid for the purpose of claiming through the scheme. New wording coming up. Collective agreement reached between an employer and a trade union is also acceptable for the purpose of such a claim. End of new wording. There needs to be a written record, but the employee does not need to have provided a written response. A record of this communication must be kept for 5 years. So the new wording is collective agreements reached between an employer and a trade union, which are presumably in writing, are also acceptable for the purpose of such a claim. So that's obviously helpful, and we've got at least one client that will breathe a sigh of relief, because that's exactly what they had done ahead of putting people on furlough. But we remain in the surprising position that the direction, which expressly envisages agreement from the employee in writing, does not chime with the directive. They don't speak with one voice. Now, helpfully, Daniel Barnett's Employment Law Bulletin published a letter which he had received from HMRC in response to a query which he had raised with them, and which they had then consented to him publishing through his Employment Law Bulletin. Key parts of the letter state, quote, HMRC will act at all times in accordance with the direction. HMRC's interpretation of the direction is set out in our published guidance. It is our expectation that customers should consider the guidance in the first instance when seeking to understand the operation of the scheme and HMRC's interpretation of the direction. You have asked for clarification about the requirement for the employer and employees to agree to commence furlough. I can confirm that we stand by the interpretation that we have articulated in our guidance, which is consistent with the direction. Put simply, the employer and employee must reach an agreement, and an auditable written record of the agreement must be retained. It does not necessarily follow that the employee will have provided written confirmation as such that an agreement was reached in all cases. Well, the obvious interpretation of this is the HMRC are going to insist that the guidance note and the direction are both saying the same thing, when it is clear they're not. Those who did English A-level or similar will be thinking, well, we're in Alice in Wonderland territory here, Humpty Dumpty. When I use a word, it means just what I choose it to mean, nothing more, nothing less. Since HMRC are now insisting that two things that are contradictory mean the same thing, what are we going to do? Well, I think the first point is it does make it harder for HMRC subsequently to deny anyone's entitlement to a furlough payment on the grounds that they followed the guidance note. If HMRC is saying they say the same thing, and the guidance note is pretty explicit that you don't need written consent, and indeed authorisation by employment law, whatever that means, is sufficient, that has got to be helpful. But I don't think it puts beyond doubt the question as to whether or not an employer who simply instructs an employee to go on furlough has to have a document evidencing agreement. It's understandable that HMRC are focusing on something that is auditable, and this may be the key point. The auditable point is the existence of a written document putting the individual on furlough, but we know from what HMRC have said, it does not have to be a document signed by the employee or a written consent. A written communication to the employee placing that individual on furlough has always been an essential part of making a claim under the Furlough Scheme from the very earliest guidance. But what does HMRC mean by saying that the employer and employee must reach an agreement in the letter to Daniel Barnett? If the employer unilaterally instructs the employee to go on furlough, can the employer rely on the lack of objection from an employee to that instruction to go on furlough, coupled with an acceptance of salary during the furlough period, as amounting to sufficient agreement for these purposes? That would probably be consistent with employment law, even if there was an initial breach of contract in the instruction to put someone on furlough. If HMRC are saying that if furlough is done and it is, quote, consistent with employment law, unquote, is that going to be good enough for their purposes? They will have the auditable written document and they don't need to see evidence and consent from the employee. But this seems to confuse agreement to being furloughed with the rather different question of whether the employer has authorisation under the contract to furlough the employee unilaterally. It's looking increasingly as though the written record is the key document with no need for written proof of consent, and the issue of agreement is being subtly downgraded. Why the direction can't be amended to make the point clear is certainly beyond my comprehension. In the circumstances, there's going to be a residual risk that there is a need for agreement to be furloughed, and a mere written instruction to furlough might be challenged. However, employers who have already furloughed staff with no other adverse changes and without consent, and who are still troubled about the point, may take comfort from the HMRC letter, which, as I say, was published with their consent. Pros and cons of taking action to regularise the position, particularly through retrospective consent, were what we discussed in our previous podcast. Going all the way back then to the issue of sick pay and employees who are sick at a point at which they are furloughed. If HMRC are insisting there is no difference between the guidance note and the direction on the issue of whether or not the employer needs written consent from the employee, then presumably the same insistence will apply to the issue of whether the employer can furlough an employee on sick leave, where, again, direction goes one way, guidance note goes another. So on that basis, employers should point to the guidance and rely firmly on that to substantiate their claim in respect of that employee for furlough monies. So, I hope that's all helpful. We will be doing another podcast shortly on issues around return to work. We think this is going to be one of the big issues coming up for employers. We've done a fair amount of thinking, as of course have others, and I will hope to put out another podcast later on this week on that very subject. So in the meantime, of course, stay safe for everyone, and I will probably aim to put another podcast out. I'm going to aim for Friday. Let's see how we do on that subject. And either on this one and especially on the next one, I would be very interested in any feedback that people have, because we're all grappling with a whole new process here. No one has got a monopoly on good ideas. And so if anyone does have any bright ideas about how employers might handle this, please do let me know. Happy to give credit where credit's due, of course. All right then, until the next time, everyone, stay safe. Take care.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.